Hello, welcome to Vidu Law Niti. Today's topic is about sources of Hindu law. Now let us learn the slight introduction of the sources of Hindu law. The term dharma is associated with Hindu law as we all know as per Hindu mythology the word dharma implies obligation. According to Dharma, in Hindu law refers to a variety of responsibility, similarly to social, legal, and spiritual responsibilities. Dharma can indeed be defined as a concept of justice, that is, nyaya, in this context. In sources of Hindu law, they are divided into two sources. They are ancient sources and modern sources. In ancient sources, they are Shrutis, Smruti, digests and commentaries, and customs. In modern sources, they are divided into justice, equity, and good conscience, judicial decision, and legislation. These are we will be learning in the sources of Hindu law. Ancient sources, Shruti, Smruti, and customs are the three primary ancient sources of Hindu law. Commentaries and digests, in addition to these three texts, are considered ancient Hindu law sources. Now let us learn in detail. In ancient source, the first one is Shruti. Ancient law or Hindu law is considered to be a divine law. Sacred law was revealed by God Himself. It is essentially revealed by the divine to the Rishi and Munis, that is, sage. Shruti in a Sanskrit word means something which has to be heard. The Vedic people lives are often described in Shrutis. It made up the Vedantas and Upanishads and the four Vedas which are Rig Veda, Yajurveda, Samaveda and Atharva Veda. The four Vedas are Rig, Yajur, Sama and Atharva Veda. The Rig Veda is the oldest Veda, contains mostly the speech of gods and a law of sacrifices. The Yajurveda, which comprise rituals and mantras. The Sama Veda, which contains musical notes and prayers. The Atharva Veda, which contains musical notes and prayers, contains magical speech. The next one is Smriti. It comes from the Sanskrit word smri, which means to remember. Smriti in basic term pretends to God's words that the sage forgot to tell in one's original form, but which the sages recalled and wrote in their own words. Thus, Smriti translates that which is remembered. In simple terms, the recollection of Rishi handed down to us. It contains purely law. They actually contains with religious and moral laws, and there are mixture of law, religion and morality. In Smritis, there are two main topics, that is Dharma Sutras and Dharma Shastras. The Dharma Sutras means these were written between 800 to 200 BC. They comprised local rituals and customs as well as Vedic preaching on various tasks that a person must carry out in various relationships. The Dharma Shastra means our moral code of conduct is stated. It was based on Dharma Sutras and was more precious and systematic when compared to other texts. The three most important issues that Dharma Shastra deals with are Achara, Vyavahara, and Prayaschitta. The next one is commentaries and digest. The law of the Smriti was empiric and regressive, and in the course of a time, several commentaries and digests were written on it. The authority of several commenters varied in different districts, and thus arose the school of law, which are operative in different part of India. There are two types of school, Dayabag and Mitakshara. Moreover, it is only because of the numerous commentaries available from various authorities that these schools could evolve and properly studied. Let's discuss schools of Hindu law in detail later on. Next one is custom. In India, custom is the most widely used and recognized source of Hindu law. Customs were valued in all the Shrutis and Smritis. However, usage is not the same as custom since usage is a common practice. Specific basic requirement must be met for a custom to be valid, namely, the custom must be put into practice over a long period. It is known as custom. It must not be immoral or ethical repugnant. In some places, it is regarded as a law. The tradition must be consistent in the essence. It must also be specific and not varying. It must be reasonable and not violation of any public policies or law. There are four types of customs. Local custom, which are applicable to the particular locality like a country, state, district, town, or a village and binding on all residents of the locality. Class custom, which are applicable to a particular caste or a community or a followers of the particular profession or occupation. Next is family custom. Those customs which are applicable to the particular family only and do not apply to persons who are not a member of such family. The next one is modern sources of Hindu law. In this modern sources, the first one is legislation. In the modern source of Hindu law, it has been an important factor in the direction of reforming Hindu law. It was difficult to fix principle of law on several areas. The British government passed certain acts which have effect of changing the religious nature of Hindu law at several instances. The legislation are concentrated, easily accessible, ascertainable and have authority. These are the easiest way of making the law uniform. The most legislation aware reforming in the nature was starting the Caste Disability Removal Act 1850 to protect the rights over property of an person who has converted his religion or has been expelled from the caste or community. Next one is the Hindu Widows Remarriage Act 1856 to give Hindu widows a right to remarry. Next is Hindu Will Act 1870. Hindus did not have any law which allowed them to make a will. This filled a gap. Next one is Special Marriage Act 1872 to allow interreligious, intercaste or intercaste marriages. What all we know now, there was a old legislation. Now let us go to modern legislation. In 1944, a Hindu Law Committee was the purpose of this committee to make the uniform code for Hindus and bring all Hindus under this code. A draft code was made in 1948, but Hindus said no. They said this new code would be an attack for their sacred law. Later, Jawaharlal Nehru decided to drop this idea. Ambedkar did not like dropping this idea, so he resigned in 1951 as protest. The code was anyway implemented in four parts. They are Hindu Marriage Act 1955, Hindu Succession Act 1956, Hindu Minority and Guardianship Act 1956, the Hindu Adoption and Maintenance Act 1956. These acts are modified the law applicable to Hindus by retaining the fundamental framework and by reforming the framework to certain degree. Well, next one is judicial decisions. After the establishment of the British rule, the hierarchy of the courts were established. It constituted an important source of the law. A precedent is not merely an evidence of the law, but also source of the law, and the courts are bounded to follow the precedents. Legislation and judicial decision are not a source. They have modified and supplemented the pure Hindu law, and now they have emerged as important source of present Hindu law. Today, the decision of Privacy Council are binding on all the lower courts in India, except where they have been modified or alternated by the Supreme Court. whose decisions are binding on all the courts except for itself. The decision of Privacy Council, Supreme Court and the High Court in the form of President are played an important source of modern Hindu law. Example, law relating to adoption, prior's duty of the son to pay father's debt, absolute power regard to ancestral property in Dayabag. Next is equity, justice and good conscience. It is a branch of legal system may be said to mean the principles or rules emerging in the course of administration of justice, particularly in those cases where on account of inadequacy of law, the judges invoke certain general principle on the basis of justice, fairness and priority. Occasionally, it might happen that the dispute comes before the court which cannot be settled by the application of any existing rule in any of the sources available. Such a situation may be a rare, but it is possible because not every kind of a fact situation which arises can have a corresponding law governing it. The courts cannot refuse to settle the dispute in the absence of law, and they are under the obligation to decide such a case also. For determining such cases, the court rarely upon the basic value, norms and standard of fair play and priority. Thank you. Please like, share and subscribe. Next video will be on schools of Hindu law.